One of the highlights of the ILE schedule is the Distinguished Jurist lecture. That's particularly true today when we welcome this year's speaker, Judge Jed S. Rakoff. Judge Rakoff was nominated to the bench of the Federal Southern District of New York in 1995 by President Bill Clinton. Despite taking senior status in 2010, he's said to work harder than most active judges, and he certainly doesn't shy away from the spotlight. Judge Rakoff is known for being independent-minded and for holding firm on his convictions. On the bench and at the lectern, he doesn't appear to temper his sometimes strong views about the politics and policies of enforcement and regulation, a topic that he knows well. Judge Rakoff, who incidentally was born right here in Philadelphia, began his legal career in the 1970s. After graduating from Swarthmore and Harvard Law School, he spent a few years in private practice. He then joined the prestigious U.S. Attorney's Office in the Southern District of New York, where he prosecuted business and securities fraud cases. Working closely with luminaries at the SEC, such as Enforcement Chief Stanley Sporkin, Rakoff played a major role in transforming the Southern District U.S. Attorney's Office into a leader and pioneer in the prosecution of white-collar crime. After approximately 7 years on the government side of the table, Judge Rakoff switched sides and left for the private sector, where he developed a defense practice that made him one of the leading securities lawyers in the country. If the Southern District bench is preeminent in business and securities law, Judge Rakoff is preeminent on that bench. Judge Rakoff has brought this expertise to a variety of high-profile cases involving financial and regulatory issues. He heard important litigation against the credit rating agencies resulting out of their involvement in the mortgage-backed securities business. He presided over the $163 million settlement between the owners of the New York Mets and the trustee for the victims of Bernie Madoff's Ponzi scheme. And he sentenced Rajat Gupta, a once highly respected business executive and Goldman Sachs director, to prison for insider trading. But Judge Rakoff is perhaps best known for the stance he's taken in demanding accountability for those who engaged in the financial misconduct that contributed to the financial crisis of 2008. Judge Rakoff first sounded a warning bell in litigation between the SEC and Bank of America, in which Judge Rakoff initially refused to approve a proposed settlement because, as he put it, among many other flaws, no individual was named for what the SEC asserted was a blatant fraud orchestrated from the very top. The parties subsequently negotiated a more substantial settlement, increasing the bank's payment from $33 million to $150 million, and providing Judge Rakoff with additional information about the facts in the case. Although Judge Rakoff ultimately approved the settlement, he did so reluctantly, terming it half-baked justice. In SEC against Citigroup, Judge Rakoff went further, refusing to approve a $285 million settlement between the bank and the SEC. In his October 27, 2011 order, which you can find on the internet, and I encourage you to look it up, Judge Rakoff asked the parties 9 questions about whether or how the settlement could be justified as in the public interest. These were questions about the SEC's enforcement policies and practices, including the agency's failure to pursue high-level executives, its willingness to enter into settlements on terms that allow defendants to neither admit nor deny wrongdoing, and the agency's failure to bring contempt proceedings against financial institutions who we might call repeat offenders with respect to securities violations. After receiving the responses from both parties, Judge Rakoff rejected the proposed settlement as not in the public interest and ordered the parties to trial. The SEC petitioned the Second Circuit for a writ of mandamus to overturn Judge Rakoff's ruling, and the case, which was argued approximately 9 months ago, is still pending before that court. In the interim, Judge Rakoff has drawn widespread support for his actions, including amicus briefs filed by a number of different groups, including some highly distinguished law professors. Perhaps more importantly, Judge Rakoff's actions have served as an inspiration for his peers. Judges around the country are taking a page from Judge Rakoff's book and subjecting proposed settlements between regulators and financial institutions to far greater scrutiny. Asking tough questions before approving a settlement that is required to be in the public interest may not seem particularly innovative, but Judge Rakoff's approach is so paradigm shifting that when a judge asks those tough questions, people call it having been Rakoffed. Judge Rakoff continues to express concerns about the lack of accountability in connection with the misdeeds of the financial crisis, and his talk tonight speaks to that very topic. Please join me in welcoming Judge Rakoff.
So it's not often you get such a gracious introduction from a highly distinguished law professor. And I'm very glad my wife's not here because she would demand rebuttal time. It's really a great honor to be here at Penn. Both my parents were graduates of the University of Pennsylvania, and so I view myself as kind of a Penn alum once removed. And since I haven't been removed yet, it's really nice to be here. But seeing Judge Jordan over there makes me realize that I should start by saying that under federal law, I am prohibited from commenting on any pending case, not just a case before me, but pending before any judge in the United States. And also, I am prohibited from commenting on any issue that is likely to come before me in the immediate future. So that concludes my remarks. Thank you very much. What I think I would talk about is really in some speculations, not more than that, as to why no high-level executives have been criminally prosecuted in connection with the financial crisis. Normally I don't read my speeches. I am going to read this one because it is a somewhat sensitive subject in certain places like the Department of Justice. But I will be open for questions afterwards, so I will still have an opportunity to put my foot in my mouth later on. But 5 years have passed since the onset of what is sometimes called the Great Recession. And while the economy has slowly improved, there are still millions of Americans leading lives of quiet desperation, without jobs, without resources, without hope. So who was to blame? Was it simply the result of negligence, of the kind of inordinate risk-taking commonly called a bubble, of an imprudent but innocent failure to maintain adequate reserves for a rainy day? Or was it the result, at least in part, of fraudulent practices, of dubious mortgages portrayed as sound risks and packaged into ever more esoteric financial instruments, the fundamental weaknesses of which were intentionally obscured? If it was the former, if the recession was due at worst to a lack of caution, then the criminal law has no role to play in the aftermath. For in all but a very few circumstances, not here relevant, the fierce weapon of what we call criminal prosecution is directed at intentional misconduct and nothing less. If the Great Recession was in no part the handiwork of intentionally fraudulent practices by high-level executives, then to prosecute such executives criminally would be scapegoating of the most abusive and reprehensible kind. But if, by contrast, the Great Recession was in material part the product of intentional fraud, the failure to prosecute those responsible must be judged one of the more egregious failures of the criminal justice system in many years. Indeed, it would be in striking contrast to the increased success that federal prosecutors have had over the past 50 years in bringing to justice even the highest level figures who orchestrated mammoth frauds. Thus, in the 1970s, in the aftermath of the junk bond bubble, that in many ways was a precursor of the more recent bubble in mortgage-backed securities, the progenitors of the fraud were all successfully prosecuted, right up to Michael Milken. Again, in the 1980s, the so-called savings and loan crisis, which again had some parallels to more recent events, resulted in the successful criminal prosecution of more than 800 individuals, right up to Charles Keating. And again, the widespread accounting frauds of the 1990s, most vividly represented by Enron and WorldCom, led directly to the successful prosecution of such previously respected CEOs as Jeffrey Skilling and Bernie Ebbers. In striking contrast with these past prosecutions, not a single high-level executive has been successfully prosecuted in connection with the recent financial crisis, and given the fact that most of the relevant criminal provisions are governed by a 5-year statute of limitations, it appears likely that none will be. It may therefore not be too soon to ask why. One possibility already mentioned is that no fraud was committed. This possibility should not be discounted. Every case is different, and I have no opinion as to whether criminal fraud was committed in any given instance. But the stated opinion of those government entities asked to examine the financial crisis overall is not that no fraud was committed, quite the contrary. For example, the Financial Crisis Inquiry Commission, in its final report, uses variants of the word fraud no fewer than 157 times in describing what led to the crisis, concluding that there was a, quote, systemic breakdown, not just in accountability, but also in ethical behavior. As the Commission found, the signs of fraud were everywhere to be seen, with the number of reports of suspected mortgage fraud rising 20-fold between 1998 and 2005, and then doubling again in the next 4 years. As early as 2004, FBI Assistant Director Chris Schwecker was publicly warning of the perceived problem of mortgage fraud driven by the voracious demand for mortgage-backed securities. Similar warnings, many from within the financial community, were disregarded, not because they were viewed as inaccurate, but because, as one high-level banker put it, quote, a decision was made that we're going to have to hold our nose and start buying the product if we want to stay in business, close quote. Without multiplying examples, the point is that in the aftermath of the financial crisis, the prevailing view of many government officials, as well as others, was that the crisis was, in material respects, the product of intentional fraud. In a nutshell, the fraud, they argued, was a simple one. Subprime mortgages, that is, mortgages of dubious creditworthiness, increasingly provided the chief collateral for highly leveraged securities that were marketed as AAA, that is, securities of very low risk. How could this transformation of a sow's ear into a silk purse be accomplished unless someone dissembled along the way? While officials of the Department of Justice have been more circumspect in describing the roots of the financial crisis than have the various commissions of inquiry and other government agencies, I've seen nothing to indicate their disagreement with the widespread conclusion that fraud at every level permeated the bubble in mortgage-backed securities. Rather, their position has been to excuse their failure to prosecute high-level individuals for fraud in connection with the financial crisis on one or more of three grounds. First, They have argued that proving fraudulent intent on the part of the high-level management of the banks and companies involved has proved difficult. It is undoubtedly true that the ranks of top management were several levels removed from those who were putting together the collateralized debt obligations and other securities offerings that were based on the dubious mortgages. And the people generating the mortgages themselves were often at other companies and thus even further removed. And I want to stress again that I have no opinion as to whether any given executive had knowledge of the dubious nature of the underlying mortgages, let alone fraudulent intent. But what I do find surprising is that the Department of Justice should view the proving of intent as so difficult in this context. Who, for example, were generating the so-called suspicious activity reports of mortgage fraud that, as mentioned, increased so hugely in the years leading up to the crisis? Why, it was the banks themselves who generated those reports. A top-level banker, one might argue, confronted with increasing evidence from his own and other banks that mortgage fraud was increasing, might have inquired as to why his bank's mortgage-backed securities continue to receive AAA ratings. And if, despite these and other reports of suspicious activity, the executive failed to make such inquiries, might it be because he did not want to know what such inquiries would reveal? This is what is known in the law as willful blindness or conscious disregard. It is a well-established basis on which federal prosecutors have asked juries to infer intent, including in cases involving complexities such as accounting rules, at least as esoteric as those involved in the events leading up to the financial crisis. And while some federal courts have occasionally expressed qualifications about the use of the willful blindness approach to prove intent, the Supreme Court has consistently endorsed it. As the Supreme Court stated most recently in Global Tech Appliances versus SEB SA, a 2011 decision, quote, "The doctrine of willful blindness is well established in criminal law. Many statutes require proof that a defendant acted knowingly or willfully, and courts applying the doctrine of willful blindness hold that defendants cannot escape the reach of these statutes by deliberately shielding themselves from clear evidence of critical facts that are strongly suggested by the circumstances." Thus, I submit that the department's claim that proving intent in the financial crisis context is that proving intent is particularly difficult may strike one as doubtful. Second, and even weaker, the Department of Justice has sometimes argued that because the institutions to whom mortgage-backed securities were sold were themselves sophisticated investors, it might be difficult to prove reliance. Thus, in defending the failure to prosecute high-level executives for frauds arising from the sale of mortgage-backed securities, then head of the Department of Justice's criminal division told PBS that, quote, "In a criminal case, I have to prove not only that you made a false statement and that you intended to commit a crime, but also that the other side of the transaction relied on what you were saying. And frankly, in many of the securitizations and the kinds of transactions we're talking about, in reality, you had very sophisticated counterparties on both sides, and so even though one side may have said something was dark blue and really we can say it was sky blue, the other side of the transaction, the other sophisticated party, wasn't relying at all on the description of the color," close quote. Actually, given the fact that these securities were bought and sold at lightning speed, it is by no means obvious that even a sophisticated counterparty would have detected the problems with the arcane, convoluted mortgage-backed derivatives they were being asked to purchase. But there is a more fundamental problem with the above-quoted statement from the former head of the criminal division, which is that it totally misstates the law. In actuality, in a criminal fraud case, the government is never required to prove reliance, ever. The reason, of course, is that that would give a crooked seller a license to lie whenever he was dealing with a sophisticated counterparty. The law, however, says that society is harmed when a seller purposely lies about a material fact, even if the immediate purchaser does not rely on that particular fact, because such misrepresentations create problems for the market as a whole. And surely there never was a situation in which the sale of dubious mortgage-backed securities created more of a huge problem for the marketplace and society as a whole than in the recent financial crisis. The third reason the department has sometimes given for not bringing these prosecutions is that to do so would itself harm the economy. Thus, Attorney General Holder himself told Congress that, quote, "It does become difficult for us to prosecute them when we are hit with indications that if we do prosecute, if we do bring a criminal charge, it will have a negative impact on the national economy, perhaps even the world economy," close quote. To a federal judge who takes an oath to apply the law equally to rich and poor, this excuse, sometimes labeled the too big to jail excuse, is frankly disturbing for what it says about the department's apparent disregard for equality under the law. In fairness, Mr. Holder, who later claimed his comment was, quote, misconstrued, was referring to the prosecution of financial institutions rather than their CEOs. Moreover, he might have also been influenced, as his department unquestionably was, by the adverse reaction to the Arthur Andersen case, where that accounting firm was forced out of business by a prosecution that was ultimately reversed on appeal. But if we are talking about prosecuting individuals, the excuse becomes entirely irrelevant. For no one that I know of has ever contended that a big financial institution would collapse if one or more of its high-level executives were prosecuted as opposed to the institution itself. Without multiplying examples further, my point is that the Department of Justice has never taken the position that all the top executives involved in the events leading up to the financial crisis were innocent, but rather has offered one or another excuse for not criminally prosecuting them, excuses that on inspection, I submit, appear quite unconvincing. So, you might ask what's really going on here. I don't claim to have any inside information about the real reasons why no such prosecutions have been brought, but I take the liberty of offering some speculations for your consideration or amusement, as the case may be. At the outset, however, let me say that I totally discount the argument sometimes made that no such prosecutions have been brought because the top prosecutors were often people who previously represented the financial institutions in question and or were people who expected to be representing such institutions in the future, the so-called revolving door. In my experience, every federal prosecutor at every level is seeking to make a name for his or herself, and the best way to do that is by prosecuting some high-level person. While companies that are indicted almost always settle, individual defendants whose careers are at stake will often go to trial. And if the government wins such a trial, as it usually does, the prosecutor's reputation is made. My point is that whatever small influence the revolving door may have in discouraging certain white-collar prosecutions is more than offset, at least in the case of prosecuting high-level individuals, by the career-making benefits such prosecutions confer on the successful prosecutor. So, one asks again, why haven't we seen such prosecutions growing out of the financial crisis? I offer, by way of speculation, three influences that I think, along with others, have had the effect of limiting such prosecutions. First, the prosecutors had other priorities. Some of these were completely understandable. For example, prior to 2001, the FBI had more than 1,000 agents assigned to investigating financial frauds, but after 9/11, many of these agents were shifted to anti-terrorism work. Who can argue with that? Yet the result was that by 2007 or so, there were only 120 agents reviewing the more than 50,000 reports of mortgage fraud filed by the banks. It is true that after the collapse of Lehman Brothers in 2008, more agents were hired for some of the vacated spots in fraud detection, but this is not a form of detection easily learned, and recent budget limitations have only exacerbated the problem. Of course, while the FBI has substantial responsibility for investigating mortgage fraud, the FBI is not the primary investigator of fraud in the sale of mortgage-backed securities. That responsibility lies mostly with the SEC. But at the very time the financial crisis was breaking, the SEC was trying to deflect criticism from its failure to detect the Madoff fraud. And this led it to concentrate on other Ponzi-like schemes that emerged in the wake of the financial crisis, along with cases involving misallocation of assets, such as stealing funds from a customer, which are among the easiest cases to prove. Indeed, as Professor Coffey of Columbia Law School has repeatedly documented, Ponzi scheme and misallocation of asset cases have been the primary focus of the SEC since 2009, while cases involving fraud in the sale of mortgage-backed securities have been much less frequent. More recently, moreover, the SEC has been hard hit by budget limitations, and this has not only made it more difficult for it to assign the kind of manpower that these kinds of frauds really require, but also has led SEC enforcement to focus on smaller, easily resolved cases that will beef up their statistics when they go to Congress begging for money. As for the Department of Justice proper, a decision was made in 2009 to spread the investigation of these financial fraud cases among numerous U.S. attorneys' offices, many of which had little or no prior experience in investigating and prosecuting sophisticated financial frauds. This was in connection with the President's creation of a special task force from which remarkably little has been heard in the intervening 4 years. At the same time, the U.S. Attorney's Office with the greatest expertise in these kinds of cases, the Southern District of New York, was just embarking on its prosecution of insider trading cases arising from the Rajaratnam tapes, which soon proved a goldmine of good cases that absorbed a huge amount of the attention of the Securities Fraud Unit of that office. Well, I want to stress again that I have no inside information. As a former chief of the Securities Fraud Unit, I would venture to guess that the cases involving the financial crisis were parceled out to assistants who also had the insider trading cases. Which do you think an assistant would devote most of her attention to? An insider trading case that was already ready to go, that was near to indictment, that might lead to a high visibility trial, or a financial crisis case that was just getting started, would take years to complete, and had no guarantee of even leading to an indictment. Of course, she would put her energy into the insider trading case, and if she was lucky, it would go to trial, she would win, and she would then take a job with a large law firm. And in the process, the financial fraud case would get lost in the shuffle. In short, a focus on alternative priorities is one of the reasons I submit that financial fraud cases have not been brought, especially cases against high-level individuals that would take many years, many investigators, and a great deal of expertise to investigate. But a second and less salutary reason for not bringing such cases is the government's own involvement in the underlying circumstances that led to the financial crisis. On the one hand, the government writ large had a hand in creating the conditions that encouraged the approval of dubious mortgages. Even before the start of the financial boom, start of the housing boom, it was the government in the form of Congress that repealed Glass-Steagall, thus allowing certain banks that had previously viewed mortgages as a source of interest income to become instead deeply involved in securitizing pools of mortgages in order to obtain the much greater profits available from trading. It was the government, in the form of both the executive and the legislature, that encouraged deregulation, thus weakening the power and oversight not only of the SEC, but also of such diverse banking overseers as the OTS and the OCC. It was the government, in the form of the Fed, that kept interest rates low, in part to encourage mortgages. It was the government, in the form of the executive, that strongly encouraged banks to make loans to low-income persons who might have previously been regarded as too risky to warrant a mortgage. Thus, in the year 2000, HUD Secretary Andrew Cuomo increased to 50% the percentage of low-income mortgages that the government-sponsored entities known as Fannie Mae and Freddie Mac were required to purchase, helping to create the conditions that resulted in over half of all mortgages being subprime at the time the housing market began to collapse in 2007. And it was the government, pretty much across the board, that acquiesced in the ever greater tendency not to require meaningful documentation as a condition of obtaining a mortgage, often preempting in this regard state regulations designed to assure greater mortgage quality and a borrower's ability to repay. Indeed, in the year 2000, the Office of Thrift Supervision, having just finished a successful campaign to preempt state regulation of thrift underwriting, terminated its own underwriting regulations entirely. The result of all this were the mortgages that later became known as liar's loans. They were increasingly risky, but what did the banks care, since they were making their money from the securitizations? And what did the government care, since they were helping to boom the economy and help voters to realize their dream of owning a home? Moreover, the government was also deeply enmeshed in the aftermath of the financial crisis. It was the government that proposed the shotgun marriages of Bank of America with Merrill Lynch, of J.P. Morgan with Bear Stearns, and so forth. If in the process mistakes were made and liabilities not disclosed, was it not partly the government's fault? One does not necessarily have to adopt the view of Neil Barofsky, former Special Inspector General in charge of oversight of TARP, that regulators made almost no effort to hold accountable the financial institutions they were bailing out, to wonder whether the government, having helped create the conditions that led to the seeming widespread in mortgage-backed securities markets, were all too ready to forgive its alleged perpetrators. Please do not understand me. I am not alleging that the government knowingly participated in any of the fraudulent practices alleged by the Financial Inquiry Crisis Commission and others. But what I am suggesting is that the government was deeply involved from beginning to end in helping create the conditions that could lead to such fraud, and that this would give a prudent prosecutor pause in deciding whether to indict a CEO who might, with some justice, claim that he was only doing what he fairly believed the government wanted him to do. The final factor I would mention is both the most subtle and the most systemic of the three, and arguably the most important, and it is the shift that has occurred over the past 30 years or more from focusing on prosecuting high-level individuals to focusing on prosecuting companies and other institutions. It is true that prosecutors have brought criminal charges against companies for well over 100 years, but until relatively recently, such prosecutions were the exception, and prosecutions of companies without simultaneous prosecution of their managerial agents were very rare. The reasons were obvious. Companies do not commit crimes, their agents do. And while a company might get the benefit of some such crimes, prosecuting the company would inevitably punish, directly or indirectly, the many employees and shareholders who were totally innocent. Moreover, under the law of most U.S. jurisdictions, a company cannot be criminally liable unless at least one managerial agent has committed the crime in question. So why not prosecute the agent who actually committed the crime? In recent decades, however, prosecutors have been increasingly attracted to prosecuting companies, often even without indicting a single individual. This shift has been rationalized as part of the attempt to transform corporate cultures so as to prevent future such crimes. And as a result, it has taken the form of deferred prosecution agreements or even so-called non-prosecution agreements in which the company, under threat of criminal prosecution, agrees to take various prophylactic measures to prevent future wrongdoing. Both kinds of agreements have become, in the words of the former head of the Department of Justice Criminal Division, quote, a mainstay of white-collar criminal law enforcement, close quote, with the department entering into 233 such agreements over the past decade. But in practice, I suggest, this approach has led to some lax and dubious behavior on the part of prosecutors with deleterious results. If you were a prosecutor attempting to discover the individuals responsible for an apparent financial fraud, you go about your business in much the same way you go after mobsters or drug kingpins. You start at the bottom and over many months or years slowly work your way up. Specifically, you usually start by flipping some lower or mid-level participant in the fraud who you can show is directly responsible for making one or more false material misrepresentations, but who is willing to cooperate and maybe even wear a wire in order to reduce his sentence. With his help, and aided by the substantial prison penalties now available in white-collar cases, you go up the ladder. But if your priority is prosecuting the company, a different scenario takes place. Early in the investigation, you invite in counsel to the company and explain to him or her why you suspect fraud. He or she responds by assuring you that the company wants to cooperate and do the right thing, and to that end, the company has hired a former Assistant U.S. attorney, now a partner at a respected law firm, to do an internal investigation. The company's counsel asks you to defer your investigation until the company's own internal investigation is completed, on the condition that the company will share its results with you. In order to save time and resources, you agree. 6 months later, the company's counsel returns with a detailed report showing that mistakes were made, but that the company is now intent on correcting them. You and the company then agree that the company will enter into a deferred prosecution agreement that couples some immediate fines with the imposition of expensive but internal prophylactic measures. For all practical purposes, the case is now over. You are happy because you believe you have helped prevent future crimes. The company is happy because it has avoided a devastating indictment. And perhaps happiest of all are the executives or former executives who actually committed the underlying misconduct, for they are left untouched. I suggest that this is not the best way to proceed. Although it is supposedly justified in terms of preventing future crimes, I suggest that the future deterrent value of successfully prosecuting individuals far outweighs the prophylactic benefits of imposing internal compliance measures that are often little more than window dressing. Just going after the company is also both technically and morally suspect. It is technically suspect because under the law, you should not indict or threaten to indict a company unless you can prove beyond a reasonable doubt that some managerial agent of the company committed the alleged crime. And if you can prove that, why not indict the manager? And from a moral standpoint, punishing a company and its many innocent employees and shareholders for the crimes committed by some unprosecuted individuals seems contrary to elementary notions of moral responsibility. These criticisms take on special relevance, however, in the instance of investigations growing out of the financial crisis, because, as noted, the Department of Justice's position, until at least recently, is that going after the suspect institutions poses too great a risk to the nation's economic recovery. So, you don't go after the companies, at least not criminally, because they are too big to jail. And you don't go after the individuals because that would involve the kind of years-long investigations that you no longer have the experience or the resources to pursue. In conclusion, I want to stress again that I have no idea whether the financial crisis that is still causing so many of us so much pain and despondency was the product in whole or part of fraudulent misconduct. But if it was, as various government authorities have asserted it was, then the failure of the government to bring to justice those responsible for such colossal frauds bespeaks weaknesses in our prosecutorial system that need to be addressed. Thank you very much.
Terrific. So Judge, you're not yet off the hook because you agreed to take questions. That might have been a foolish agreement, but please, Carrie?
Oh, I'm sorry.
Sorry, go ahead. I'll let you.
Sir.
Yes, so one of the more creative criticisms of your rulings and your approaches to these cases has not been that you're wrong, but that you're almost unique. Now, as was said, there are more judges approaching these cases as you have, but the argument goes that as long as there aren't that many judges who approach these cases in the way that you do, it is somehow unfair that it's kind of up to chance as to whether these companies get you as their judge or another judge, and that leads to too many inconsistencies in rulings. How would you respond to that?
Well, first of all, I really don't think I'm in any respect fundamentally different from any other federal judge. Every federal judge that I'm familiar with is very concerned with all these kinds of issues. I've been fortunate that in a few cases that have come my way, the issues were presented in stark fashion, and that allowed me to have my say, so to speak. But while always, there will be disagreement among federal judges, and different judges take different approaches, and that's the way it should be. I don't really think that I am, to be frank, special in any respect. And if you don't believe me, ask my daughters.
So I wanted to follow up on your second hypothesis about the government's involvement preceding this whole mess. And I wondered if you might comment on two possible implications from that, which I think is very convincing the way you presented it. One possible implication from that might be that should lead us to question the subsequent government reports that say it's industry's problem, they were engaged in fraud. And I wonder if you think we should be skeptical about government reports that now blame the financial crisis not on government policy, but on bad industry behavior as a CYA, reaction by government officials. And the second implication I wondered about is just maybe as if you have any comment as a legal matter, what implication that government posture has. In your remarks, you said that the defendants could always say, well, we were just doing what the government wanted us to do. Is that just a nice persuasive appeal that one can make to a jury in a case like this, or or does the government policies preceding the financial crisis speak to whether there really was willful blindness, for example, by some of these high-level managers? Is that the legal hook or relevance of the governmental policy decisions?
So those are very good questions, unfortunately. I think one has to distinguish between creating the conditions that made lies more likely and actually participating in the lies. So I think a strong argument can be made that the government created the situation where, or helped create the situation where banks would be strongly tempted to extend mortgages to persons who they know are really not creditworthy because A, the government was encouraging them to do that, and B, they could then pool those mortgages and sell them for a lot more money than they would ever make off the interest from the mortgage. So even if the mortgage ultimately defaulted, they'd come out ahead. But it's one thing to create the conditions. It's another thing to knowingly participate in a lie. Fraud is really a very simple concept, I think. Fraud is lying to obtain money or property. And I don't know of any evidence that the government itself knowingly participated in the making of lies. Now, I do think, and this goes to your second point, that particularly in some of the situations that arose in the aftermath of the crisis, there was tremendous pressure being brought on certain financial institutions to absorb other institutions that were failing. And that created a situation where it would be easy to say afterwards, well, the only way we could get this done was to do X or Y or Z. The government didn't tell us to do it, but that was what we had to do. So I'll put a little flesh on that bone. In the Bank of America Merrill Lynch case, which is now totally over in all respects, including all appeals, so I can talk a little bit about it. The government, Bank of America had always had an interest in Merrill Lynch, but the government said over Labor Day weekend in 2008, right after Lehman Brothers had collapsed, Merrill will collapse if you don't acquire it. And so they acquired it, or signed the agreement to acquire it over a 3-day period. A situation that was, I think, fraught with potential for difficulties. The SEC later alleged that indeed Bank of America made false statements in connection with promising things to Merrill Lynch that they didn't reveal to their own shareholders, like $5.6 billion of bonuses for Merrill Lynch executives, which, according to the SEC, was not only not revealed, but was affirmatively denied by the proxy statement issued by Bank of America. The Bank of America, I disapproved the initial settlement of that case for $33 million. I approved a later settlement for $150 million, but it wasn't so much the increase in the amount as the restructuring of that agreement. But there was a private class action brought that was settled for $2.4 billion, suggesting that maybe there was some truth to the allegations. But I think one might have been able to argue, if those cases had ever gone to trial, that we had to do this in order to get the deal done. So that's the kind of thing that I think might appeal to some prosecutors. Maybe whether it should appeal to them or not is a different question, but I think it might. Now, I should reveal that this is Steve Fraden, my former partner. He's about to ask a question. He's just about the smartest guy I know. I think I want to leave right now. But go ahead.
Thank you, Jed Rakoff. You mentioned certain other financial scandals in addition to these financial issues that you've recently faced. The Milwaukee insider trading scandal and the Enron-WorldCom scandal. And I think that it's fair to say that both of those sets of scandals involved situations that were individuals involved, there were companies involved, and that were not necessarily widespread or endemic in financial America. So could one prosecutor could single out Paucity, Belkin, whatever other individuals involved. Same thing is true with Enron and WorldCom. But don't you think that one of the difficulties that prosecutors have to have with the recent financial crisis is that, in fact, the kinds of behavior that you described were endemic. Everybody did it. Now, I know that everybody's doing it is not a very good criminal defense, but the fact is everybody did it. And it's very difficult to distinguish among financial institutions and senior executives of financial institutions in terms of culpability.
Yeah. So several answers to that. First, I think both the junk bond bubble and the S&L bubble were pretty widespread. They weren't as widespread as the financial crisis we've just gone through, but they were not one firm isolated or one savings and loan isolated. They had a broader reach. Secondly, I guess I don't share your cynicism about banking executives. I don't think they were all doing it. And I think you can see significant differences between different institutions, different providers of mortgages, and the like. And one evidence of that is how the class action, I mean, the plaintiff's securities class bar, if they even get a sniff of fraud, they'll, attracts them immediately. And they have brought actions against certain institutions, not against others. They've settled on much smaller amounts with certain institutions than with others. So I think there is evidence out there that it wasn't quite so endemic as you're suggesting. There were differences of degree. There were differences of intent. So I really think there could have been a prosecution. Finally, I guess the theoretical question that's implicit in your point is if a crime is endemic to an entire industry, and I don't think that was the case here, but if it was, does that let everyone off the hook, meaning it was okay because everyone was doing for everyone to lie and cheat and engage in fraudulent practices, assuming hypothetically that's what was going on? I think that would be a ridiculous defense. I think that would be, we might as well throw in the rule of law if that's a defense. Another person I don't want to call it, Judge Jordan.
You mentioned a couple of areas, Judge Rakoff, where the government had a hand. One is in creating the circumstances
Well, though I think you can have a whole debate about this, I do think the repeal of Glass-Steagall was a mistake. And if we ever get the Volcker rule, how many years have we been waiting for the Volcker rule? That is at least intended to address some of the problems you focus on, and change the incentives and change what banks can and cannot get their money from doing. In terms of prosecutorial incentives, I guess I would come back to the third point I made towards the end of my talk, which is I really think prosecuting companies is a bad idea. It's very au courant in certain circles. There's a professor at Penn Law School who just sent me a whole book that he's written about why we not only need prosecution of corporations, we need more prosecution of corporations, and he's a very fine professor and he makes a lot of good arguments, but to me it's the easy way out for the prosecutor. They just turn it all over to outside counsel. The company can really not fight back as a company to a criminal prosecution. That's what Arthur Anderson really showed. So the company is going to come to the bargaining table sooner or later. The prosecutor says, aha, I've got another notch on my belt. And prophylactic measures are put in place, some of which are more important than others. I don't think that has remotely the deterrent effect of a few prosecutions of high-level individuals. I think, to give an example, the insider trading prosecutions that the U.S. Attorney for the Southern District of New York has brought has had a far greater impact than just prosecuting a company because it was involved in some sense in insider trading. And I also think that it's really, whenever you go after a company, you hurt a lot of innocent people if it's a big company or even a relatively small company. And that just, I think, is morally distasteful to me. Yes?
Judge, there's this comparison that keeps being made to the late 80s and the recession of 89 to 92 and Milken and Boesky and Keating, and then we had Enron, and we had prosecution and law reform in both cases. Neither of the reforms in those antecedent cases was fundamental, I think. Even Sarbanes-Oxley was incremental. It regulated along established lines and intensified. I think after 2008, we needed a fundamental law reform, and maybe the reason why people didn't go out and look for fraud at the top was because fraud wasn't going to solve the problem. We had more pressing regulatory concerns, which had to do with redefining and rethinking. It is true that the Goldman affair, centered on Fabrice Touré, occurred just prior to Dodd-Frank's enactment and gave it a little extra traction. But I wonder whether a more concerted government effort in 08, 09 to impose accountability on bankers at the top by developing fraud cases might have deflected attention and energy from law reform efforts that are still very much needed.
Well, I mean, it's an interesting hypothesis, but I think unlikely. I don't see why it's an either-or situation at all. You have all sorts of agencies, the SEC, the OTS, the OCC, that have the power to go to address institutional problems. You have, of course, At the top, the president and his board of economic advisors and so forth focus hugely on restoring the economy. This is just another piece, and it was a piece that was, in my view, ignored. I also think that from a standpoint of the public's feeling that justice should be done, and their feeling that justice was not done, the failure to prosecute played a very negative role in the mindset, if you will, the psychology of recovery. Now, again, there's a danger of scapegoating, and I don't want to minimize that. But if there was real fraud, as an awful lot of people, including some commissions, thought, then what kind of message are you sending if you don't go after it? So I don't see it as the Hobson's choice that you do. Yes?
Judge, as you know, J.P. Morgan Chase has repeatedly engaged in massive fraud, which has really hurt the American people, including, hundreds of thousands of people losing their
Why do I think this is a question I can't respond to?
Now, this week in Vietnam, a banker who swindled the Vietnamese people out of $25 million got the death penalty. Would you recommend this as a law in the United States as a deterrent to prevent our banks from continually to engage in this massive fraud?
So so I like that very straightforward question. In 2003, I declared the federal death penalty unconstitutional. That lasted about a nanosecond before I was reversed by the Second Circuit Court of Appeals. So my answer is no, I would not recommend that. Yes, ma'am.
I was wondering what your thoughts are on the government's recent strategy of using FIREA to prosecute financial institutions civilly, perhaps as a substitute for not bringing criminal cases.
I can't comment on that because the leading case was the case just tried before me, which was the United States against Bank of America for countrywide problems emerging from the countrywide mortgage situation. Under FIREA, the jury determines liability, the judge determines penalty. The jury found liability against both the bank. Bank of America was only involved as the purchaser of Countrywide. The real liability was Countrywide's, and against a mid-level executive, Rebecca Barone. And now the judge has to decide what the penalty is, and I'm the judge. So I can't answer your question. Yes?
I was just wondering, do you see any historical analogies further back? Like you said, the Great Depression. What was the response there? Obviously, there was the breach of the SEC. Was there any great outpouring for criminal prosecution?
My recollection is that there were significant criminal prosecutions. I think the head of the New York Stock Exchange was criminally prosecuted right after then. I'm a little fuzzy on that, but there was not in place, as there is now, experienced white-collar prosecutors. It was an occasional thing. It was really Robert Morgenthau, when he was the U.S. attorney in the Southern District in the 1960s, who created the first serious white-collar prosecution group, and that then spread to many other fine offices. But there were prosecutions. As I say, I think it was growing. Whitney was the name of the head of the New York Stock Exchange. Now, that may have been from earlier activity. I'm not sure, but I thought it was partly in reaction to that.
See, you've tapped in Joel, to Judge Rakoff's expertise as a historian as well, and I think you might have just given him a subject to explore further in his next speech. Judge, thank you. This has been terrific. Please join me both in thanking Judge Rakoff and at a reception downstairs in the Great Hall where those of you who hadn't had a chance to ask questions can follow up. Thanks very much. And this, I think, is a deal toy. So I think it falls within what we're allowed to. Yeah.
Thank you. Thank you.